Thank you for listening to our sixth and final webinar about the amendments introduced by the FIC Amendment Act. In this session, we shall discuss training and guidance issued by the FIC, as well as measures to promote compliance with the FIC Act and the implementation of financial sanctions. In previous webinars, we discussed the following measures to promote compliance with the FIC, namely governance and the development of a risk management and compliance program. During this session, we shall have a closer look at the training and guidance issued by the FIC as measures to promote compliance with the FIC Act. Training. An accountable institution is required to provide ongoing training to its employees to enable them to comply with the provisions of this Act and the risk management and compliance program which are applicable to them. The training of employees is also a tool to manage risks within an organization. Employees that are able to identify risks are able to manage those risks within their means and in their relevant departments, or in the alternative, will be able to alert senior personnel of the potential of risks. It is important to ensure that records are kept of training. This can, for instance, be recorded by using a training register. Guidance and directives issued by the FIC. The Financial Intelligence Center publishes public compliance communications, guidance notes, and directives to provide further insight, clarification, and interpretation of various aspects of the FIC Act. Institutions must ensure that they monitor the publication of these additional guidance and adhere to the guidance and directives provided by the FIC. Financial sanctions. The Financial Intelligence Center is responsible to administer target financial sanctions, or TFS, adopted by the United Nations Security Council in the context of combating the financing of the proliferation of weapons of mass destruction. TFS measures imposed will restrict sanctioned persons and entities from having access to funds, property, and financial services in relation to such funds and property. What are institutions' obligations in relation to the implementation of targeted financial sanctions? Institutions are prohibited to acquire, collect, use, possess, or own property of persons or an entity who is identified by the TFS list, and are thus required to implement measures that will prevent it from transacting or continuing a business relationship with a person or entity whose name reflects on the TFS list. The submission of a terrorist property report to the FIC if the organization is in possession or control of property of a person listed on the TFS list, and the submission of suspicious transaction or activity report if there are suspicious transactions or activities that may be connected to a person or an entity listed on the TFS list. If a client reflects on the list, it must freeze the assets and not proceed with any transactions. In order for an institution to comply with its obligations, accountable institutions whose products or services are at high risk of being used for terrorist financing, or an accountable institution that is more likely to come into contact with persons or entities on the sanctions list, should screen clients and prospective clients against all sanction lists. Screening can be done during the client take-on process, form part of the ongoing due diligence process, and when the UNSC adopts new TFS measures and adopts the TFS list.